1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်262 The State Agricultural Marketing Board Plaintiff vs. AUNG Trading Company Defendant ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Regular Suit before Uttar Pradesh The State Agricultural Marketing Board Plaintiff vs. AUNG Trading Company Defendant Carriage of guineas by sea Loss of the guineas Suit for compensation Whether the written contract of agreement is enforceable in law, act of court as defense, whether the agreement is void under Section 23 or 56 of the Contract Act, hell, the manner in which the document was executed would go to show that the parties never intended that it should be a contract of agreement without which there is to be no binding contract between the parties. The facts of the case clearly indicate that the parties intended to make and believed that they had made a binding oral agreement on the carriage of guineas to which Exhibit Gange forms only a part. In this view of the matter, the question as to whether the document in question is enforceable in law or not does not arise at all. Shankale Narayandas Mondade vs. The New Mofusa Company Limited and others AIR 1946 PC page 97 refer to Hell Father, an act of God is available as a defense only when it is impossible to provide against the occurrence and it is not an act to show that it was not reasonably possible to provide against it. In claimant whether conditions were not unexpected on the west coast of Arakan especially during the monsoon seasons and it cannot therefore be said to be so unexpected that no human foresight could reasonably anticipate it. The sinking of LCT numbered 495 in the present case on account of strong wind cannot be said to be due to this matter or an act of God. Manindra Nath Mukherjee vs. Mathura Das Chatterbuj AIR 1964 Kalakata page 175 Cashin vs. Peter Walker and Son Warrington and Barton Limited 1941 2 Allahabad ELR page 693 at page 695 refer to Hellfather, assuming that the contract between the parties comes within the purview of the Burma Carriage of Goods by Sea Act, there is no provision in the Act prohibiting the defendants from foregoing any benefit bestowed upon them by the Act, where a person of full age with competent understanding enters into a contract freely and voluntarily, which is not expressly prohibited by law, it cannot be said that the contract is either illegal or against public policy. Hasbury Laws of England 1954, that edition volume 8, page 143, refer to held further at the time when the parties enter into the contract of carriage, the defendants, as carriers by sea, must have anticipated that there were certain perils of sea journey, especially during the monsoon season, when the sea is usually rough and stormy. Therefore, the defense of frustration of contract is not available to the defendants. K.M. Modi versus Mohammed Siddiq and 1, 1947, RLR 423, Rangoon. Telephone Company Limited versus the Union of Burma 1948, BLR, page 527, refer to Nhu Kin for the plaintiff, Thong Mao for the defendants. Udapi, Judge, the State Agricultural Marketing Board, hereinafter referred to as the plaintiff, sue AUNG Trading Company of Agep, hereinafter referred to as the defendants, for recovery of debt 127,056. It is the case of the plaintiff that by a writing date 27 May 1957 and signed by the defendants at Rangoon, the defendants offered to transport 200 bales of guineas from Rangoon to Agep in their LCT numbered 495, and that the plaintiff, after accepting the said offer, deliver 200 bales of guineas, which were however lost in total when the defendants LCT numbered 495 sank off the west coast of Barunga Island on the first day of June 1957. That the defendants undertook absolute liability for the loss of the said guineas from whatever cause, and that the defendants had refused to compensate the value of the guineas, which amounted to Jet 127,056. The defendants, while admitting the execution of the writing date, the 22nd May 1957, contended that it was not admissible in evidence as it was not properly stamped, and that it was not enforceable in law as it was a unilateral agreement. They then questioned the valuation of the guineas and pleaded that the absolute liability agreed to by the defendants was subject to act of God or vis major, which was responsible for the total loss of LCT numbered 495, with the plaintiff bills of guineas on 1st June 1957. On these pleadings, my learned predecessor joined the following issues. Issues 1. Whether the agreement or memorandum date, the 22nd May 1957, is admissible in evidence and or enforceable in law. 2. Whether the defendant's liability was subject to force majeure or act of God. 3. Whether the sinking of LCT 495 was due to force majeure or act of God. 4. What was the value of the 200 bills of guineas involved in the suit? 5. To what relief, if any, is the plaintiff entitled? Additional issue 1. Whether the agreement is void under Section 23. 29 or 56 of the Contract Act. Issue number 1. It has been asserted by the plaintiff that the document date the 22nd May 1957 was not an agreement contemplated by the parties, and that it comprised the memorandum of the defendant's offer to transport 200 bales of candies from Rangoon to Agyep on conditions mentioned therein, and that the contract was complete only when the plaintiff accepted the offer and delivered 200 bales of candies. In other words, the plaintiff's case was that the agreement between the parties was an oral one. It cannot be disputed that an agreement of this nature needs no writing, and the real test whether there is a completed contract between the parties without drawing up a deed is to see the intention of the parties, whether there is to be no binding contract till a formal document is executed, or whether the document is merely to be a record of the bargain which the parties are under contemplation. Thus, it has been ruled by the Judicial Committee of the Privy Council in Shangale Narayandas Mundate versus the New Mofusel Company Limited and others 1. That by the law of India, an oral contract is valid and enforceable, but in such a case, it is a question of construction whether the execution of the further written contract is a condition or term of the bargain, or whether it is a mere expression of the desire of the parties as to the manner in which the transaction already agreed to will, in fact, go through. In the present case, it is clear from the testimony of Maungji, plaintiff witness 2, and Tin Mao, defendant witness 1, who has once worked with the plaintiff, that the procedure adopted by the State Agricultural Marketing Board in the transport of their candies was to call upon the carriers register with them whenever there were candies to be consigned, and that the carrier concerned was to sign on the document similar to that of the exhibit Kange, and after that the candies were handed over to the carrier for transport. Maung then, the agent of the defendants, admitted in his evidence that he had to see only the clerk, not the officer concerned, before the document exhibit Kange had to be signed by him. The manner in which the document was executed would go to show that the parties never intended that it should be a contract of agreement without which there is to be no binding contract between the parties. The facts of the case clearly indicate that the parties intended to make and believed that they had made a binding oral agreement on the carriage of candies, to which exhibit Kange forms only a part. In this view of the matter, the question as to whether the document in question is enforceable in law or not does not arise at all. Then, the document having been impounded under Section 33, Stamp Act, is admissible in evidence in view of the proviso A to Section 35, Stamp Act. The issue will therefore be answered in the manner indicated above. issue number 2 and 3 will be considered together. An act of God or vis major is an operation of natural forces which no human foresight can provide against and of which human prudence is not bound to expect the possibility. It is a direct and violent as well as a sudden and irresistible act of nature, as a prudent man could not by any amount of ability foresee would happen, or if he could foresee that it would happen, could not by any amount of care and skill resist. In other words, an act of God is available as a defense only when it is impossible to provide against the occurrence, and it is not alleged to show that it was not reasonably possible to provide against it. The facts of the present case must, in the light of the above principle of law, be scrutinized whether the sinking of LCT numbered 495 was due to an act of God. According to the story of Captain Udaunyo, defendant witness 3, master of the ill-fated LCT, the weather worsened from the 30 May 1957 when the velocity of wind reached up to gale force and big wave began striking against the side of the vessel, with the result that seawater got into the engine room, which was eventually floated in spite of valiant attempts of the crew to pump the water out. The vessel then began listing in the Ross Sea, although the cargoes were jettisoned to correct the list, and finally sank on the 1st June 1957. It must be borne in mind that during the monsoon weather, stormy condition along the west coast of Arakan is not uncommon, and gales of considerable intensity are by no means unusual. There is the long statement of Captain Udaunyo to the effect that the velocity of wind reached up to force 5. It is significant that the defendants had not chosen to support their captain version by any weather report issued by the Meteorological Department. Captain Udaunyo did not explain what he meant when he said that the wind reached force 5. Be that as it may, even assuming that an exceptionally strong wind had swept at the time, such inclement weather conditions were not unexpected on the west coast of Arakan, especially during the monsoon season, and it cannot therefore be said to be so unexpected that no human foresight could reasonably anticipate it. In Manindranath Mukherjee vs. Mathura Das Chatterjee 2, the law on the subject of vis major or act of God was exhaustively discussed, and it was decided that an act of God is an operation of natural forces so unexpected that no human foresight or skill could reasonably be expected to anticipate it. In the town of Kalagata, during the monsoon season, stormy weather is not unusual, and storms of considerable severity are by no means unprecedented. Wind velocity of from 31 to 48 miles per hour are sometimes experienced in Calcutta and gusts of from 28 to 33 miles per hour are not uncommon in the monsoon season. Therefore, a gust of wind with a velocity of less than 27 miles per hour in the town of Calcutta during the monsoon season cannot be said to be so unexpected that no human foresight could reasonably be expected to anticipate it, and cannot be regarded as vis major or act of God. In Cashin vs. Peter Walker and Son, Warrington and Barton, Limited 3, Howlett Judge has thus remarked, counsel for the plaintiff submits and counsel for the defendants concede that before wind can amount to an act of God, so that the defendants escape liability for the action of the wind must not merely be exceptionally strong, but must be of such exceptional strength that no one could be reasonably expected to anticipate or provide against it. I do not think that it is necessary to examine such authorities as there may be, but having regard to what has been decided in respect to other natural phenomena, such as, for instance, an exceptionally high tide or an exceptional downfall of rain, I think that counsel for the defendants was correct in making that concession. For the aforesaid reason, the sinking of LCT numbered 495 in the present case, on account of strong wind, cannot be said to be due to vis major or an act of God. The answer to issue number 3 would therefore be in the negative. In view of the answer to issue number 3, the issue number 2 does not arise for consideration. Additional issue number 1. It has been submitted on behalf of the defendants that the Burma carriage of goods by Sea Act has given them certain protection as carriers by sea, and that the contract which imposed liability on them, otherwise than as provided by that Act, must be regarded as void under Section 23, Contra Act. The learned advocate for the plaintiff countered that the Burma carriage of goods by Sea Act has no application in the instant case, inasmuch as no bill of lading, as stated in Section 4 of the Act, had been issued in respect of the goods carried by the defendants. The document in question, namely Exhibit 5, which was issued by the defendants in respect of the guineas, which they agreed to transport, is clearly a freight receipt and not a document of title. It is therefore rather doubtful whether the contract of carriage between the parties falls within the ambit of the Burma carriage of goods by Sea Act. Even assuming that the contract between the parties comes within the purview of the Burma carriage of goods by Sea Act, there is no provisions in the Act prohibiting the defendants from foregoing any benefit bestowed upon them by the Act, where a person of full age, with competent understanding, enters into a contract freely and voluntarily, which is not expressly prohibited by law, it cannot be said that the contract is either illegal or against public policy. In Healthbury Laws of England 4, it has been said, as a general rule, any person can enter into a binding contract to waive the benefits conferred upon him by an Act of Parliament, or, as it is said, can contract himself out of the Act, unless it can be shown that such an agreement is, in the circumstances of the particular case, contrary to public policy. Statutory conditions may, however, be imposed in such terms that they cannot be waived by agreement, and, in certain circumstances, the legislature has expressly provided that any such agreement shall be void. The plea under Section 29 Contract Act, which has been referred to in the issue, has not been pressed at the time of argument, so far as the defense of frustration of contract as provided under Section 50C Contract Act is concerned. I'm of opinion that it is clearly untenable inasmuch as the plaintiff had already carried their part of the contract by handing over the bills of guineas to the defendants, who were under a duty to hand it over to the plaintiff representative at a gap, and whose failure for its delivery could not, as noted above, be attributable to an act of God. Frustration of contract is a premature determination of agreement lawfully entered into between the parties, owing to circumstances so fundamental as to be regarded by the law both as striking at the root of the agreement and as entirely beyond what was contemplated by the parties when they enter into the agreement. Vide K.M. Modi vs. Muhammad Siddiq and 1-5N Rangoon Telephone Company Limited vs. the Union of Burma says. At the time when the parties in the present case enter into the contract of carriage, the defendants as carriers by sea must have anticipated that there were certain perils of sea journey, especially during the monsoon season, when the sea is usually rough and stormy. I am therefore of the view that the defense of frustration of contract is not available to the defendants. The answer to the issue will be in the negative. Issue number 4. AUNG has computed the value of the guineas at that 127,056, and his computation has not been challenged by the defendants in his cross-examination. The exhibit Gange document by which the defendants undertook to bind themselves also disclosed that they would compensate the amount as faced by the chief movement officer whenever any loss and or damage occur to the guineas or twins consigned. The answer to the issue will therefore be that the value of the guineas is that 127,056. In the result, the plaintiff's suit is decreed with costs